Your Honour, my name is French, initial MF, and I appear on behalf of the defendant, James Beatson. Your Honour, the Crown is prosecuting my client under Section 419 and 421 of the Criminal Code, Queensland. The evidence that the Crown is relying on is the admissions made by my client in a recorded interview, and the recording is inaudible. Your Honour, I submit that the Crown's evidence is inadmissible and should be excluded. I rely on the two judicial discretions. I will be relying on the fairness discretion and the public policy discretion. Your Honour, if it pleases the Court, I would now like to begin my first submission. Your Honour, I submit that the evidence be excluded on the discretionary ground that it would be unfair to admit the evidence against my client. I rely on Section 130 of the Evidence Act of Queensland, which provides that evidence can be excluded if the Court is satisfied that it would be unjust. I also rely upon the decision of Christie, Lee and Hasler. In Hasler, Justice Thomas interpreted the process for applying the fairness discretion. I submit that the evidence is of relatively slight probative value, and the prejudicial effect of its submission would be substantial. Your Honour, my client's confession has a low probative value. My client is 14 years old and is considered a child within the meaning of the Youth Justice Act 1992, and he is also of Aboriginal descent. My client should have been treated in accordance with cultural competency laws. However, the police officers did not follow any cultural competency procedures as they did not avoid gratuitous concurrence from occurring. The police officers asked my client questions that required a yes-no response, and due to this, my client responded yes to try and get out of the uncomfortable and confrontational situation that he was put in by the two police officers. My client was in a vulnerable and unfair position during the questioning, and I submit that the cultural considerations lower the value of the evidence and that it is outweighed by its prejudicial effect. Your Honour, the admissibility of the Crown's evidence should be rejected due to the unfairness it imposes upon my client. That concludes my first submission, Your Honour. If it pleases the Court, I would now like to begin my final submission. Your Honour, I submit that the evidence has been improperly obtained by the police officers and is such that public policy requires the confession to be inadmissible. To satisfy this discretion, I rely on the 5 factors of Bunning and Cross. Your Honour, the police have deliberately disregarded the law by breaching the following sections in the Police Powers Responsibilities Act, herein referred to as the PPRA. The police officers failed under Section 392 to notify my client's parents that he was under arrest and of his whereabouts. The police officers did not caution my client under Section 431 and did not tell my client that he had a right to silence under Section 397. The police have also breached Section 418 as my client was not provided the opportunity to exercise his right to contact a relative, a friend, or a lawyer. The police officers questioned my client whilst he was in the police vehicle and also at the police station. Your Honour, my client should not have been questioned until he was provided with a contact person or a lawyer. I rely on the case of the Queen and Adamic, in which the Court found that the accused was not given an opportunity to contact a solicitor, and as a result the Court held that those admissions were excluded. Your Honour, the police have also breached Section 420 as legal aid was not notified that my client was in custody. Despite the police officer arranging a support person under Section 420 subsection 4, the support person that my client had was a middle-aged man who was non-Indigenous. Your Honour, there is a high degree of culpability of the police officers involved in obtaining this evidence from my client. I submit that the evidence has been obtained so dishonestly that by admitting it, the Court would be risking community faith in the interests of justice. The police's improprietary and unfair conduct has brought about an unreliable confession. Your Honour, the second factor is that the Crown is relying on my client's admissions exclusively. As mentioned earlier, the evidence has a low probative value as it was obtained with disregard of my client's cultural needs. This low cogency and low probative value should find in favour of exclusion. Your Honour, the conduct was not a genuine response to the circumstances. I submit that the police officers did not follow the correct procedures as a means of convenience, and as a result, they were not compliant with the PPRA. Your Honour, the nature of the offence is breaking and entering and burglary. The breaking and entering offence is less severe. However, it may be argued that maybe the burglary offence would be more severe. However, despite this, the police did not follow the correct procedures to obtain this confession from my client. The final factor is that the purpose of the PPRA is to ensure that the police officers are enforcing the law and complying with the correct conduct. The police acted recklessly and disregarded the legislation. Your Honour, all the factors from Bunning and Cross weigh in favour of exclusion of the evidence. Your Honour, I urge the court to regard the evidence as inadmissible using both the fairness test of Christie and Hasler and the public policy test in Bunning and Cross. Your Honour, unless there is anything further, that concludes my submissions.